Good evening, colleagues, and welcome to our second webinar of the academic year. It's almost 6 o'clock, and we do have a healthy number, so we'll give another 2 minutes and we would start. We would like to finish at 7, but it gives me great pleasure to welcome my friend and colleague. I call him Ani, but you can call him Dr. Aniruddha Rajput. I've put his details and link in the chat. I'm not going to do a lengthy introduction, as those of you who attend our webinars know. But the link is in the chat. And one of the things you can actually do is you can connect with him on LinkedIn. I think we have to be adding that now. You can connect with him on LinkedIn. Annie, welcome to SOAS Arbitration and Dispute Resolution Center and to our webinar.
Thank you very much.
Perfect. We can hear you. Yeah. Thank you. And so I start by saying thank you for accepting our invitation to share some thoughts. We both sit on the UNIDRA working group on reform of international investment contracts, where we have very interesting and healthy debates on these issues around how to balance these interests. And so today we're going to be picking up on stabilization clauses. And, we will engage with how we got to where we are on stabilization clauses and what the future is like, where we're moving towards. And that is this whole idea of moving away from stabilization clauses. So instead of basically hampering the state from doing anything, the question then becomes, can we meet the interest of the foreign investor and the state by including renegotiation clauses? And that is what we would engage with this evening. So the way we would proceed is that Annie would speak and share his thoughts, which sometimes are explosive, so which is what we welcome at the center. And then if you have any questions, if you don't want to forget, you can put it in the chat function, but as usual, you can raise your hand and you can speak directly. A few housekeeping, the webinar is being recorded. Thank you very much, Annie, for giving us permission to do that. So we would record so we can populate our YouTube channel that we do have, which has our videos. So please watch some of those when you're bored out of your mind and have nothing better to do. Please engage with the videos. That's about the only housekeeping. Annie, I think we're ready to go. So I think it might be useful for you to start with just a little bit about your background, because we do have some students on the webinar as well, and we like to get to know people's background, how they got into this work, because then that sort of encourages our students that there is light at the end of the tunnel, that they're not just wasting their time with studying, and they can actually make some good money from this practice as well. So I'm going to hand over to you. Thank you so very much, Annie. Please.
Thank you. Thank you so much, Emilia. I have to, of course, begin by thanking SOAS, SADRC, and Professor Onyema, who has not only been a colleague, but a very dear friend. It's always a pleasure, even just to see her. So it's more pleasure to engage with her intellectually. And I must thank UNIDRA for providing that opportunity to engage with her intellectually. She asked me to begin with a bit of a personal tour of how I've got where I have got. One of the benefits of getting where I have got is the opportunity to make friends across continents and with people who have just fascinating brains and perspectives. And one of them is my dear friend Emilia. So it wasn't an easy journey. No journey in life is easy. I come from a very traditional middle class Indian family where you could either be a doctor or an engineer. And intelligent students were never supposed to become lawyers because they were for those who got less marks. But I think I could get where I got with, if I may say, not with a lot of how to say self-praise, but with a lot of humility. I had to work really hard, and I still continue to work donkey hard. So that's one thing which is very important in life, I have felt. But to be very brief about myself and to talk more about the topic, what I would say is, if I have to trace my intellectual journey, which is probably the best way to describe my professional journey, is I started my career before the Supreme Court as a lawyer. I started as a counsel, which is the equivalent of a barrister. I was lucky to work in a very big chamber. I used to do at least 50 to 60 cases per week, which is probably more than what several barristers do in their life. But that's the nature of Indian litigation game is. I did that for almost 12, 13 years. Got to a point that now I can eat, breathe, smell advocacy. You can wake me up. In fact, there were occasions when I was walking into the court and somebody came running and said, could you just argue our case, which is just coming up in the next 10 minutes? We'll brief you right away. Because once you become a soldier who has fought on the field, your brain is trained in a certain manner. But I felt I needed something more academic. So I decided to give up the practice, do a PhD. And my background was international commercial arbitration and private international law before national courts, domestic courts, and arbitral tribunals. I wanted to move more towards public international law. So I did a PhD in investment treaty arbitration because I thought it would serve as a good bridge from my commercial law background to come into public international law. And I wrote mostly about public international law in my thesis. And once I made the transition, then I started moving into more traditional public international law things like law of the sea, boundary disputes, neutrality, use of force. And those are the things which form the courses which I teach at different universities, of course, at National Law University, Delhi, and also at University of Vienna. So I think it's all about being passionate, and young people are far more passionate than I am. So keep your passion. There are difficulties. There will always be difficulties. Things won't go the way you expect. But what is important is to keep your focus, dedication, hard work. And trust me, suddenly from nowhere, somebody comes, knocks on your door, and you have several opportunities opening up. And I think once you are exploring yourself, you're thinking more, you're giving new challenges, intellectual challenges to yourself, new doors open, new opportunities come. Unidhwa was one of them. I thought my connection with international commercial arbitration contract law is completely over. But here you go, Unidhwa brought me back into what I did as my bread and butter for almost 13, 14 years. And it has been almost 8, 10, 12 years before. But still, it's good to be back because it's like a muscle memory, which always comes back. So as a student, keep building your muscle memory as much as you work in the gym. Make your brain work as well as an intellectual exercise. And trust me, as you go along in life, opportunities come along when you don't expect them. Having said that, if I may, Emilia, may I turn to stabilization clauses?
Yes, and can I quickly say thank you very much for that thought around when opportunity comes and recognizing that it is an opportunity and getting on with it. That is really important. So thank you very much for sharing that. Please, yes, stabilization clauses.
Thank you so much. Let's start with the stabilization clauses. Professor Onyema already gave you a very good background of what the debate of stabilization clauses is, but let me try to take you a little further. So as she discussed, I'll try to stick myself to 35, 40 minutes or maybe a bit more. And then if there are any questions, we'll see how the discussion goes, and we'll modulate the duration to ensure that you all have time to ask questions and we can finish at the dot of 7. Today's discourse of the relationship between a foreign investor and a state, and I suppose you all understand when I mean a state, I mean a sovereign state, that is a sovereign country, not a province or a part of a country, but a country by itself. So the relationship between a foreign investor and a country in today's discourse is understood essentially in the context of investment treaty arbitration. Because there are around 3,000 bilateral investment treaties, free trade agreements. There are a few hundred awards which are issued, and we have like a big stack of arbitration awards in relation to investment treaties. So we tend to think that the relations between a foreign investor and a sovereign state are essentially regulated by investment treaty arbitration. But even before investment treaty arbitration picked up, even during the lifetime of investment treaty arbitration, state contracts have continued to exist. They have been used extensively. Of course, there's no doubt a large part of those state contracts and the disputes arising therewith have been consumed by investment treaty arbitration. But that by no means has made the state contract or the law of state contract redundant. What we are seeing today is that there is a shift, not a complete shift, but there are signs of a shift from investment treaty arbitration towards state contracts. And due to that shift, there's also demand from the industry, that is the investors, and there's also a demand or a change in policy from states to move towards state contracts from investment treaties. And the reason for that shift is when you are entering into a state contract, you are aware which is that entity you are entering into a contract with. And you are also aware which terms of engagement are you entering into through the contract with that particular entity. Unlike in investment arbitration, where you make an open offer to the whole world effectively, because you have things like you could probably do round tripping and restructuring to avail benefits of treaties. There's a possibility you even provide open treatment standards, which are quite broad in investment treaties. So straight contracts allow you to have a control over the relationship. And what I mean by control is at least be aware of what you are entering into and with whom you are entering into. So state contracts have existed, they continue to exist, and in the future it is expected that their use will enhance, and at least some states have made express policies in support of state contracts. But state contracts are not simple. There's a certain peculiarity of a state contract as opposed to a normal contract. Because in a normal contract, both the parties are at parity. They're at equal level and equal status. But the peculiarity of a state contract is on the one side, you have a state. And the moment there is a state, although the state is engaging into a commercial relationship in its contractual or commercial capacities, one cannot forget that the state also possesses the sovereign capacity, which can be used anytime it wants to. Therefore, there's always the threat that a state would make a new law or change a new law, which would either directly or indirectly affect the contract which has already been entered into. In fact, one of the most rather famous or infamous state contract arbitration, because it was the earliest state contract arbitrations which spoke about stabilization clauses, was the Sapphire arbitration. And in Sapphire arbitration, there was a law which was made by Russia saying that the state cannot conduct arbitrations. You cannot have an arbitration with a state, a private party. Arbitration can only be between state to state. So effectively, the protection under the contract was wiped off by the law itself. It is possible for a state to make a law which makes the entire contract ineffective by saying that, well, the state never had the capacity to enter into such contract, or to affect the contract indirectly. For example, if the contract is in relation to an extractive industry, coal extraction, and the state says after this, coal will not be extracted by any private company, full stop. So the state hasn't done anything to affect the contract, but the contract is still destroyed nevertheless through indirect means. Therefore, you always have the possibility that there may be exercises which could be legitimate, in public interest, genuine, For example, if a state decides to limit or ban coal exploitation, it is probably understandable in light of the situation of climate change. But while this is happening, there's also a possibility of arbitrary or discriminatory measures which are intended to get rid of a foreign investor in a certain sector. Now, why this is important? Because under state contract, an investment tends to be a sunk-in investment. That is, the investor is not trading on the share market. He's not buying some shares, some bonds, or other financial instruments and sell off and go away. An investor under a state contract will be coming and investing in the state, generating employment, contributing to the economy. And to do that, the investor has to make a lot more initial investments. And the nature of these sectors, particularly extractive industry, is that these contracts are for 20 years. And for the first 5 to 10 years, the investor is simply investing without any returns, because the returns come in the later phase. And of course, the returns that come are of a much larger scale. That's the reason why investors are there in the first place. Nobody is there for charity. I think we should be clear about that. But the only question is how much is the profit and what should be the profit margin. Be that as it may, but as I told you, due to the peculiarity of the relationship, rather the contractual relationship between an investor and a host state, there tends to be a separate treatment of state contracts. Even in domestic laws, for example, in France, there's something called contrat administratif or administrative contracts, which are a different legal realm of contracts as opposed to normal commercial contracts. Now, in this contractual framework, where does stabilization clause fit? The task of stabilization clause, to put it in very simple terms, is to ensure that the stability of the contract is retained. Now, there are multiple definitions of a stabilization clause because the definition differs from the type of the stabilization clause, and there are multiple versions. These are clauses put into contract, therefore they are an outcome of negotiation. It's highly unlikely that two negotiations will result into the same outcome because it depends on the comparative negotiation position of each of the sides. Therefore, in one study, it was found that in the contracts of the past, it was mostly African countries who used to have these absolute freezing stabilization clauses. But the policy in the European countries is that they would not allow such freezing stabilization clauses because clearly they had an upper hand in negotiation with the foreign investors, unlike some of the African countries, which they used to have in the past, which is understandable because it was an era immediately or few decades immediately after their independence. And immediately after their independence, they had to make efforts to support their economy, and they needed foreign investors and had to enter into stabilization clauses, sometimes with quite broad implications. Stabilization clauses, to give a very general definition, are a promise made by the state through a contract not to change its regulatory framework, which would adversely affect the contract and the foreign investor. Basically, there is a guarantee given by a state through a contractual provision saying that there would be no new laws or no changes to existing laws which would prejudice the interests of the foreign investor. Now, there are multiple versions of stabilization clauses, as I already told you. The first version is called a freezing clause, which is probably the most radical stabilization clause, and that's the one which has received a lot of criticism throughout the world. Freezing, as the name indicates, means that the state cannot make new laws. You're frozen. And that freezing is normally on the date of entering into the contract or any other date so specified in the contract. A freezing clause is basically tying the hands of the state from performing its own regulatory functions, because any such regulatory function which affects the foreign investor prejudicially, even in the slightest manner, can be stopped. But there are other types of freezing clauses as well. They're called the partial freezing clauses, which tend to exist, or some sectors demand such stabilization clauses. That is a stabilization in relation to taxation. A state may promise that an investor, that no import duty would be imposed on the products that the investor is importing till the for the period of the contract, or there might be benefits in relation to some domestic taxes, direct taxes, indirect taxes. So those would be in the category of partial stabilization clauses or partial freezing clauses. The third category, in fact, the rest of the categories are similar. They have the similar effect. The third category are called intangibility or inviolability clauses. An intangibility or inviolability clause means that a state makes a promise that it will not change the contract in any manner, either directly or indirectly. Now, it's having the same effect, freezing the hands, it's tying the hands of the state, but it's the different things which are being protected in order to ensure that the hands of the state are tied. The next category is allocation of burden clauses. In allocation of burden clauses, states have the freedom to change the law, but once the state has changed the law, it has resulted into some loss to the foreign investor, then that loss is to be allocated, and that loss would be allocated back to the state. So what happens is that the state's right to regulate is recognized, but it's ineffective because you still have to compensate. Broadly speaking, we can draw three conclusions from these various types of traditional, let's call them traditional stabilization clauses. First, states cannot make new laws or change new laws, so their regulatory framework is frozen. Second, states may be allowed to make and change laws, but they have to compensate, so the effect is not very different. State still has to pay, which may not be possible for a small developing state, but which has a lot of rich resources. And at the same time, it is possible. The third category is that the state can make and change laws, but those laws would not apply to the foreign investor. So the foreign investor is excluded from the application of those laws. Now, what are the consequences of these freezing clauses? Because unless we understand these consequences, we'll not be able to understand why has been there a transition and a shift from stabilization clauses to renegotiation clauses. There are two fundamental problems with stabilization clauses, with the very concept of stabilization clauses. The first fundamental problem is a constitutional question. And the second fundamental problem, I call it systemic question. I'll elaborate each of these. The constitutional question is, today, there are issues raised in domestic courts about the legality of stabilization clauses. Now, stabilization clauses are normally entered into by the executive. Sometimes the legislation also makes, the legislature also gives a legislative approval to a contract which includes a stabilization clause. But the effect of a stabilization clause, seen from a domestic constitutional law or public law perspective, is that it is a promise made by the parliament to tie future parliaments. Now, one parliament cannot tie a future parliament because every parliament is sovereign, has freedom to decide what it wants to do, which laws it wants to make, which laws it doesn't want to make. So can one government abide the parliaments which are going to come in the future for the next 2 or 3 decades? And that has raised a constitutional question. And it has resulted into two cases. One case is from Israel, where the case was called the Movement for Quality Government in Israel versus the Prime Minister, where the High Court of Israel concluded that a stabilization clause, which was in the form of a freezing clause, violated the Israeli constitution. Therefore, it could not exist in the contract. The contract, the stabilization clause from the contract was struck down. That's the proper word which is used in public law or constitutional law. Now, that was the same argument. So what the High Court said, well, how is it possible that this government can promise for the future? Added to that, the government had also given the guarantee to the foreign investor that we will make sure that no bill is introduced in the parliament which will interfere with investors' right during the period of the contract. to which the court said this is just unimaginable because there's no government is permanent. Any government can change any time. You cannot make such promises. The position of the Israeli High Court, therefore, was that a freezing clause which limits the freedom of the states to make and change laws entirely is not legal, is invalid. In some observations, in fact, there was a separate opinion by a judge. In the separate opinion, the judge also expressed the view that even a limited stabilization clause in the form of a tax freezing clause may also be contrary to the Israeli constitution. The second case is of Niger Delta Development Commission versus Nigeria Liquefied Natural Gas Limited, the case from Nigeria. Here, the issue wasn't raised directly, but here the issue came in obiter because there were issue in other litigation, and then the court was observing as to what are the implications of that other litigation on this case. And the observations of the court were that there are problems with freezing clauses, and freezing clauses could not be entered into. Of course, the vigor of the reasoning was not like the Israeli High Court because the court wasn't posed with the question directly, unlike the Israeli court. Here, the issue came on the side, on the tangent, but the court did respond to it, saying that, which is an enough indication that if in the future any such issue is brought up, it is possible that the Nigerian courts may not take a view which is very different from the Israeli courts. So that's the constitutional problem. So you make all these efforts, you make a state to give all these promises, an investor is happy that he has managed to win over, to extract a stabilization clause from a state, but some non-governmental organization approaches the court under public law and effectively succeeds in the process. The second challenge is a systemic question. And that systemic question is, of course, very much a matter of public international law as well as constitutional law. If a state is making a promise not to make new laws, not to change laws, or not to apply its laws to the foreign investor under the contract, then what happens to the obligations of the state in relation to human rights, labor standards, and protection of environment and climate change? All these obligations arise from public international law. For example, efforts by a state to implement the Paris Agreement, efforts by a state to implement its obligation on International Convention on Civil and Political Rights, efforts made by state to implement its obligations under the International Labour Convention obligations. In fact, states are entering into free trade agreements. European Union is insisting that its partners who enter into free trade agreements adhere to the highest available standard of International Labour Organization. If that is being pushed, states are entering into these obligations at the international level, then can they make a promise to one investor that whatever laws we are making in relation to protection of human rights, environment, climate change, labor standards, even health, we are out of a pandemic, it seems distant past, but we know what it was, we have fresh memories of it. Could you then say, no, you cannot make laws which are going to affect the contract? Another serious area is of emergencies, economic emergencies or other types of emergencies which happen within the country which need to be responded. So what happens is that the state has no power to respond to these situations. And there has been a major debate and shift of discourse, and that's one of the reasons which has pushed the debate from stabilization clauses towards renegotiation clauses. So the British Petroleum, BP, had a project in Azerbaijan, Georgia, and Turkey. In this project, they had, of course, entered into a traditional stabilization clause because these countries were keen on getting BP. They wanted their resource to be used. They wanted to monetize their resources. So they agreed to a broad stabilization clause, which was in the form of a freezing clause. The moment this clause was entered into and the clause was put in the public domain as a part of transparency efforts by BP, there was a backlash from NGO, other human rights groups. BP immediately understood the problem and decided to enter into what is called human rights undertakings. That is, while on the one hand, it was seeking protection maybe in relation to tax to ensure that its commercial viability is not destroyed due to change of government or whatever reasons. But at the same time, it made a commitment to protect human rights, to uphold human rights. This debate led to a lot of movements in different paths. And I think one movement which is important for our purposes is the efforts which were taken by the UN, by the special rapporteur for business and human rights, the then special rapporteur, John Ruggie, who's made lasting contribution to the field of business and human rights. He did a study on stabilization clauses in human rights as a part of his mandate as the special rapporteur for business and human rights. So he studied different contracts. Of course, at that time, several contracts were not publicly available. He made effort to access those privately, at least to see them. He also engaged objectively in all the debates. He didn't take a perspective either from the business side or purely from the government side. He tried to have a balanced view and see where does one stand in relation to this whole area. His conclusion was that it is impossible to get rid of stabilization clauses entirely. The reason being, stability of contract is essential. Yes, states need the freedom and discretion to make change laws, but let us not forget that this discretion is also abused. That abuse also needs to be checked. But it is not just a relationship between the foreign investor and the host state. There are multiple actors behind who are equally important, who want the contract to be stable and performable. Performable in the sense that it survives through its life of 2 decades, and not only survives, but the financial viability is sustained and not destroyed over a period of 2 decades despite volatility in the international market. And therefore, he found out, and he made a note of it and emphasized the point. He said, international financial institutions which provide financial support, not support, which basically give loans to these big corporations in order to perform these functions, insist on some kind of stability of contract. Now, that is so important because what these big corporations have is the technical expertise, is the technical know-how, the ability to employ. The countries which are inviting these companies are inviting them because they expect them to bring this technical know-how. The second major question is of getting finances. It's not possible for the state to get finance by itself. It can get finance from IBRD, the World Bank, but there are limits on getting that finance. IBRD has already said, try to get private finance. So the state has to tie up with the investor, and using the reputation and ability of the investor to perform the contract, of course, the raising of the finance is not done by the state. It's ultimately the liability of the investor because the investor has to pay off the debt. So those who are financing these transactions are demanding some kind of stability of the relationship because they simply don't want the relationship to deteriorate. And if it deteriorates midway through the contractual process, it creates a lot of problem. And these are huge funds that we are speaking about. So how to move forward? How to keep the balance? So what we see today is there has been a move towards what is called the renegotiation clauses. Sometimes they're called stabilization and renegotiation clauses. I think the use of stabilization here is really for the optics. By optics, I mean to give the assurance to the funders that the contract is stabilized. But the effect of the stabilization clause is altered and it is brought in the domain of renegotiation clauses. Before I move to, I want to make a couple of quick comments about what happened ultimately to John Ruggie's work. Based on John Ruggie's work, the Office of the High Commissioner of Human Rights produced what is called Principles on Responsible Contracts. The principles on responsible contract are again an advice as to how states need to be careful when they're entering into contracts and enter into contracts responsibility from the perspective of human rights. And in Principle 4, it provides for stabilization clauses. It simply says that states need to be careful while entering into stabilization clauses. And the care that they need to take is that they ensure that their freedom to regulate is protected, because freedom to regulate is something essential, fundamental, and quite important. The further development was in the form of OECD guiding principles on durable extractive contracts. So as the name suggests, OECD guidelines on durable extractive contracts. These are contracts in the extractive industry, and these are durable. That is, these are long-term contracts. The OECD guidelines very clearly say no freezing clauses. But they do say you may need tax freezing clauses due to the circumstances. So they would be in the nature of limited freezing clauses, if not absolute freezing clauses. But as I said, the trend and also the demand of the investors is moving towards renegotiation clauses, because they're realizing even if you have a stabilization clause, it may not be implemented. It may be struck down by domestic courts. There might be a lot of criticism in the public domain, which would affect their reputation in the market. So they are entering into renegotiation clauses. So what are these renegotiation clauses? Renegotiation clauses or a standard well-drafted renegotiation clause can be divided into 4 categories. The first is the trigger event. The second is the goal of renegotiations. Third is the procedure for renegotiations. And fourth are carve-out clauses, or clauses for protection of regulatory freedom. Now, as I said, all contracts differ. You can't say all contracts are the same. It also depends on how it is negotiated, how well it is negotiated, and also the background of the negotiators. The more they know, the more they want to protect. The first is the trigger event. As the name suggests, these clauses, the goal of these clauses is to start renegotiations between the state and the foreign investor. But when should that renegotiation be started? If there is an open-ended renegotiation clause, then there's always a tendency on either side, either on the side of the investor or on the side of the state, to frequently ask for renegotiations. Such frequent demands for renegotiation again bring a certain amount of instability. For example, if the government has changed and the new government say, okay, let's renegotiate because we didn't like the past government. So we want to renegotiate the whole thing. I think if you look at some of the major economies in the world, that's what is happening. They are canceling the treaties, renegotiating, probably having the same terms, but then saying, look, we have got a better deal for you guys. So having too much renegotiation can be problematic. Likewise, even from the investor side, for example, if there are fluctuations in the market and the investor wants to not just protect the profits, but enhance the profits, they may want to use it as a tool to renegotiate the contract and put pressure on the state. So too much or too open-ended renegotiation clause is not a good idea in the interest of both the parties. So there has to be a specific trigger event. That trigger event is normally defined in the renegotiation clauses as adoption of a regulation, law, legislation by the state which adversely impacts the foreign investor or the contract. So the trigger event means the moment when the duty to renegotiate commences. It commences if the state is making or changing laws which impact the contract directly or impact the surroundings of the contract in a manner that it becomes difficult or impossible to perform and implement the contract. So it might be the contract directly or circumstances around it. Also, one needs to keep in mind that normally these trigger events are not trivial events, like, oh, we lost a few £1,000 here and there. No, that can't be a trigger event. It has to be something very serious. And that's the understanding of trigger events across all renegotiation clauses. They don't come into play easily, because if they come into play easily, you may recall I told you, if there's frequent renegotiations, that affect the stability of the contract. If the bar for a trigger event is too low, then there's a possibility of having a renegotiation clause very frequently. So the bar has to be high enough. Then Who has the right to invoke the trigger event? Normally it is the investor, but sometimes even states, some of the African states in the modern contracts have a clause saying that it is us who would also retain the right of trigger event. Tanzania has some of these contracts where they say that we would like to also invoke the right to renegotiate. The second is, what is the goal of renegotiations? Sometimes the contracts are silent. They say it's all open, renegotiate, and you can find whatever you want to find. So it's a process to renegotiate the contract, but of course it will be a process to achieve an economic equilibrium. Now, some of these renegotiation clauses are also called economic equilibrium clauses. That is, clauses which aim to reintroduce the equilibrium of the contract. Now, there's another question: equilibrium at what point in time? Equilibrium at the time of entering into the contract, or at the time of the making of the legislation, or at a future date, or economic equilibrium as it was understood by the investor. Ideally, it should be clarified in the contract. That tends to be clarified. Sometimes it's always the economic equilibrium as it existed before the adoption of the legislation, because it's the legislation which has disrupted the economic equilibrium, and the idea of renegotiation is to bring back the economic equilibrium. Sometimes what happens is that there is an amount of discretion left, and as a result of renegotiation, what states do is states say, all right, we will not compensate you for this, but we will compensate you in some other manner. For example, we might give you another block to exploit in addition to what we gave to you already, because you're suffering some kind of a financial loss. Now, today what happens is, when an investor gets into a jurisdiction, there is a detailed financial assessment done. So they're clear as to how much profit they can make. Once they see that profit is being cut into, then they want to ensure that there is this renegotiation to keep the economic balance. And normally a state is also reasonable, because state would say, well, you also need to make profits, reasonable profits. If that's what your profit margin is, then I'll make sure that I'll give you some other forms of benefits, maybe tax benefit in some other manner. I won't give you any direct compensation. I will not restrain my regulatory exercise, but I'll make sure that you're not utterly devastated. The third part of renegotiation clauses is the procedure for renegotiation. If the renegotiation is open-ended with no outcome intended, it is prone to abuse. But if it provides that you have to renegotiate within 30 days, you have to follow a certain procedure. If you don't follow that procedure, then if there is a dispute resolution clause, and if there is dispute resolution in the future, that could be treated as unreasonable behavior and breach of the terms of the contract as well. So there is pressure on the parties to make sure that there is performance of this, there is adherence of the obligation to renegotiate. The fourth category is most important, or not category, the fourth element of renegotiation clauses, and that is exclusion of certain types of regulatory exercises. It's also called the carve-out clauses. These carve-out clauses say, yes, you have a right to renegotiate, but in certain areas, there's no question of renegotiation. That is environment, climate change, labor standards. State has a right to insist that irrespective of the financial losses you suffer, you have to respect labor standards. You have to respect human rights. In fact, there have been some debates, if I recollect rightly, in some African countries, I think it is Nigeria itself, IISD has made a very interesting post on it, on business and human rights, and the Center for Sustainable Sustainable Investments, IISD at the Columbia University. They've said, because of the new laws, which are aimed at protecting the rights of women, there's going to be additional cost for the companies, because they need to hire human rights monitor who are women, who understand women issues. And also there should be maternity leave benefits, which were otherwise not provided as a part of the domestic law. So legislations of these type would fall in the fourth category, which would be the carve-out provisions. So that's where we stand. That's where the transition is from the freezing clauses or stabilization clauses to the renegotiation clauses, or stabilization and renegotiation clauses, whatever way you call it. We are discussing this at Unidwa, where I've already told you I have the great privilege of being a colleague with Professor Onyema and discussing these issues in greater detail. Our work is still confidential, so unfortunately I can't speak much about it. But I think in a month's time, our first draft will be in public domain. So it will be out for everybody to see as to what we have done in relation to the stabilization clauses. Since I have had the task of drafting some of those provisions, I've had the chance of intimately knowing various perspectives and various debates. But as I said, the effort at Unidwa, and that's precisely where Professor Onyema started, and that's where I think I should also end, is the challenge is how to balance, because you can't lean too much in one direction or the other. And what we were struggling at Unidwa was to precisely find this challenge. How to make sure that the freedom of states to make and change laws in public interests, which are genuine and legitimate, is protected on the one hand, and on the other hand, arbitrary exercises of sovereign power, which are going to destroy the business, should be stopped. And at the same time, when an investor is taking a risk to invest in a country, the rights of the investor are also protected, but reasonable limits are placed in that regard. I think I'll stop here. Thank you.
Thank you so very, very much, Prof, for that expose, for taking us through the different types of stabilization clauses and their impact, and what the debate is, and what we're sort of trying to find, I suppose, some form of equilibrium between both sides. So what I've been doing while you were speaking is I was just putting links to various documents that you had mentioned in the chat, and some summaries as well, just to help people, especially those who are new to the topic, to sort of find further readings and be able to engage a little bit more. Okay, we do have a few minutes for questions. And as usual, if you want to raise your hand or unmute yourself, please, and speak, that's absolutely fine. If you want to put it in the chat, that's fine. But we would love to hear your voices. Do we have any questions? Okay. Okay. So I do have, let me kick off the discussion. And Prof, just sort of thinking through the difficulties and the debates we have over climate change, and knowing the impact that exploitation of mines have on the environment. With the pullback from the US government, how do you sort of, do you have any predictions on how this may impact on this types of clauses and what we've been trying to achieve? Some of it is going to be rolled back.
Yeah, very, very, very important question. Yes, once a major economy pulls back, it creates a lot of difficulties in the overall implementation of legislations like these, which are important. But I think today we are at a phase, where there are multiple other means to enforce those obligations. And I must say the Dutch courts have taken a lead, the Urgenda, Milio Defensie cases, where the possibility of national courts being used to implement these obligations is increasing. Coupled with public law remedies, which I spoke about stabilization clauses, those would also add on to this process. So what we could see potentially is, I mean, the US courts have been reluctant on these matters, especially when it comes to extraterritorial jurisdiction. So it's impossible to enforce anything against US companies in the United States. But if the US company is outside, it's very much exposed. So, and I think these companies also realize that they cannot just go on with the government's line, because the government's line is not going to help them where they're doing the business. Where they're doing the business, the local communities are going to insist on rights. And one good thing, if I may say, of opening up of these issues is that an NGO, which is far weak as compared to these corporations, has a possibility of approaching a national court, filing a. I come from India, where public interest litigation is a major area. When I was in practice, I told you in the introduction, I spent a lot more than a decade doing this work. I did public law work, appearing on behalf of NGOs, sometimes even on behalf of companies. On all sides, I've seen what happens. So what happens is, which allows a lot of other stakeholders who couldn't have done anything. Even today, now you have the European Court of Human Rights framework where such disputes could be entertained. So it's simply impossible for, of course, most of these remedies are against the state, but you could use the pressure on the state and then put pressure on the corporation. Or in some instances, you can even file cases. There would be very much civil cases here in this country as well. The Vedanta case, which was, I think, big for Zambian mines. I think it's an interesting case because Vedanta only has 14 employees in London and no other existence. But for what it was doing in Zambia, the UK Supreme Court said, yes, there's very much, this country has jurisdiction, we'll exercise it. So today there are multiple avenues from where these obligations could be implemented. I think I'll stop there because we have somebody who has already raised a hand.
Thank you so very much, Annie. Mark, please.
Thank you so much, Professor Onyema, and thank you so much, Professor Rajput, for that excellent presentation. This area of arbitration is not quite my area of speciality, but it has given me a lot of insight into the area and further nudges into what to look into in this very fascinating area of stabilization clauses. Now, Professor, I hope I wouldn't derail the conversation. My apologies if I do so, but this is, I guess, more of a selfish question as it relates to myself. And if you don't mind, I'll take you back to the very beginning of your presentation where you were talking about yourself and your own experience and how you started off as a barrister before then proceeding to academia. So I just wanted to get more of your input and your advice on how you balance, now obviously being an established academic as well as a very established practitioner, how you balance both of them and whether you feel that there's a need to sort of have a balance between working as an academic and also as a practitioner in this day and age. And again, my apologies if I've completely derailed the conversation or your line of thought.
Honestly, I would say most of the audience who are students would be more interested in your questions. So I think you've not derailed the conversation, rather brought it back on track. So no need to apologize at all. And I'm sure Professor Onyema would agree with me on that. Because as an academic, I think you always have students in your heart. So you practice, you do things, but I think your priority are your students. And that's, I think, something which in a sense distinguishes our soul from a regular practitioner's soul.
Yeah.
So I find it fantastic to do both these things. And the reason why I do these things together, yes, it's a bit difficult to balance because it adds to your commitments. But the best part, in my view, is once you spend a lot of time in academia, when you spend a lot of time reading and thinking, it allows you to frame complex discussions in very simple terms. And I remember when I started my career as a lawyer in the Supreme Court, I told you I was doing some 50, 60, 70 cases a week, crazy amount of work. Somebody had told me, I don't remember, I'd read it somewhere, it was a good lawyer is somebody who thinks like a philosopher and talks like a peasant. And if you look at all great professors, at least in my field in international law, what you will feel is they're speaking about probably the most complex thing in the world. And they speak to you as if it's the simplest thing in the world. I always advise people, I mean, I used to teach trade law. That was the early things which I did to get into public international law. I wrote a book by John Jackson. It's called The International Trading System. That's a classical case of think like a philosopher and speak like a peasant. You give it to an undergrad student will fully understand what international trade law is about. But if you give them the Marrakesh Agreement of WTO, even a practitioner would be sweating to understand what it means, because when it was drafted, it was one of the most complex treaties. UNCLOS is the longest treaty, but WTO is the most complex treaty. So I feel as a practitioner and as an academic, I'm able to absorb a lot more information, process it, and present it. And the benefit of that of practicing in terms of academia is what you're speaking of is not just purely theoretical. Of course, making frameworks, theories is an integral part of our job. That's why we are an academic. But we are not speaking of theories which it's like, we're not speculating about the weather in Mars. Of course, we can, but it's for the scientists to do, not for me as an international law, because I don't have the skill. But what happens is if you're not connected to practice, then you start going more and more inside into yourself. And then you start thinking that your perception of the world is the reality, whereas it's just virtual. That's not how the world is outside. So you may make up things on Mars and say, well, this is how the law would be in Mars. Well, very good. Of course, law is fine. But if you start speaking of weather, there are serious issues. I think it's important to keep a balance. I think for me, it's always a question of it's a moral question. You have to, as a teacher, your students are your priority. Practice, you learn. But you don't go too much in one direction, especially the practice direction. You always stay close to students. And I think that's where Professor Onyema would fully 100% agree with me.
Thank you so much, Professor.
Thank you very much, Annie. I thought somebody else raised their hand. Yes. Ramit, please. Forgive me if I didn't pronounce your name correctly.
No worries. That was perfect, Professor.
Thank you.
Professor Rajput, thank you so much. This was very enlightening for me. I was just wondering about, is there a certain degree of overlap that happens between stabilization clauses and umbrella clauses? And how have tribunals navigated that? Any insight would be most appreciated.
Yeah, I was waiting for that and deliberately reserved that for questions because it's a topic which deserves a full lecture. What happens is now is because of, it's not just umbrella clauses. Umbrella clauses is one, but what is happening with umbrella clauses is they're using umbrella clauses to destroy the contractual terms and impose the treaty terms. But the more serious question is how is stabilization clause treated then? Because there's the question of fair and equitable treatment then. Because under fair and equitable treatment, you use legitimate expectations, which allows you to provide stabilization beyond the stabilization clause. Because then you say there were legitimate expectations. How were the legitimate expectations? You made a presentation of what, saying that, well, the energy law framework would not change. Or look at the Argentine crisis cases. They're all about the energy framework, the energy law privatization. They say energy law framework would not change. Good, so we need protection. Now, if you look at the contract would not have a stabilization clause to protect from energy law changes. It might have a stabilization clause limited to taxes. But you're able to use the framework of FET and expand the protection by using legitimate expectations. But while doing all this, I would say tribunals have done one problem for themselves for the future. They have said, well, you see, questions of stabilization clauses arise out of contract, so they are a contractual matter regulated by domestic law. BIT is a question of public international law, so it would be regulated by public international law. Now, for a long time, stabilization clauses were protected by use of public international law. So all the state contract tribunals kept using the doctrine of internationalization to internationalize contracts, to somehow force public international law. Today, tribunals are saying, no, we are going to keep these things separate. But I think once we move to state contracts, I won't be shocked if they flip again and say, well, oh, internationalization was always there. So it is complex. Therefore, I said it's that area, the relationship of stabilization clauses within the investment treaty framework and contract framework is a big topic which deserves further careful attention.
Thank you. I mean, many more questions from that response, but thank you so much. A lot of food for thought. Thank you.
Thank you so very much. Nick of time, Ramit, thank you for opening up that aspect of the debate. Annie, I don't know how to say thank you, but that was fascinating. That was really, really very clear. especially because we do have non-specialists on the webinar, and I think that it's become, you've sort of managed to break down all of that, making my own job when I have to teach my investment law class a little bit easier. So thank you so very much. And any comments, any further questions, just connect with Professor Rajput on LinkedIn, ask him questions. He will respond to you. So this brings our webinar to a close. Our next webinar, if I can find the date, but our next webinar will be next month. And next month, actually, our next event is going to be in Cairo in person. The next two events, we will be in Cairo. And then we will come back and we would resume our webinars. We have one on the 23rd of October. And our 23rd of October webinar is going to be very hands-on and practical. It's on artificial intelligence in international arbitration, how we can use it and deploy it to make our lives and work a little bit easier. So please do join us. Thank you, colleagues, and we're very grateful for your continued support. Annie, thank you so very much.
Thank you. What a pleasure to be here. Thank you very much.
Perfect.
Thanks.
Thank you. Okay. Bye, everybody. Thank you.